Hi everyone, I'm Beta Delisi, and in this video we're going to talk about how can a tenant defend themselves at a non-payment of rent hearing at the Landlord and Tenant Board. We receive many calls from landlords informing us that they've already served their tenant with a non-payment of rent notice, the N4, they've already attended the hearing, and at the hearing the adjudicator dismissed the matter. Well, here are 5 defenses that you need to know that a tenant can raise at a non-payment of rent hearing. Number 1, errors in the notice. Any errors in the notice, no matter how minor, will get your application dismissed. Errors can include missing the postal code, forgetting to put a party's name, or misspelling a party's name, or forgetting to sign the notice, or miscalculating the termination date. Again, any errors, no matter how minor, will get your matter dismissed at the board. Number 2, problems with service. As you are all aware, the Landlord and Tenant Board has their own rules of procedure when it comes to serving legal documents. If in fact the notice or the agreement, which is the consent to service by email agreement, is not signed by the parties, that notice cannot be served via email or text messages. We see time and time again that the landlord either takes a picture of the notice or scans and sends a PDF document via email to the tenant. These are not acceptable methods of service. Again, you are running the risk of having the matter dismissed due to an issue with service. Number 3, proof of paying the rent. If the tenant can provide proof that they've already paid the rent, being a bank statement showing that that deposit was made, or an e-transfer confirmation showing that that rent payment was sent, the board can actually rule on the tenant's favor that that rent payment was already made. Number 4, raising issues under Section 82 of the Act. A tenant can raise issues under Section 82 to justify reasons as to why they haven't paid the rent or why they have held back a portion of the rent. These issues can be the landlord neglecting to do maintenance and repairs, the landlord holding an illegal deposit and not returning it. Any issues can be raised under Section 82 at a non-payment of rent hearing. And number 5, raising issues under Section 83 of the Residential Tenancies Act. Section 83 issues can be raised in order to persuade the board to delay an eviction. And what I mean by that is, for example, if you have a single mother as a tenant and she's on a fixed income or her job has been affected, she can raise all these issues under Section 83 to actually persuade the board to delay an eviction. When the board hears the matter, usually they will take about 30 to 60 days to issue an order. In that order, depending on who the adjudicator sides with, they can either enforce an eviction, or if the adjudicator sides with the tenant, your application will get dismissed and you're going to have to start your matter all over again. If you have any questions regarding these 5 defenses, call us first.